Hi everyone, this is Hamida. Welcome to Safi Law Channel. Today we will discuss various important questions relating to the DPC Viva. So first we try to understand about the what is DPC. DPC in the sense what? Drafting, pleading and conveyancing. So first part, drafting means what? Here whether it may be relating to the pleading or to the conveyancing, drafting is very important thing. Drafting doesn't it is nothing but giving some knowledge about the particular facts of the case. Means giving some information related to the particular facts of the case. Whether it may be any agreement, whether it may be any relating to the contract, whether it may be any relating to the any pleadings or any deeds. In the sense what? It is a legal document, means the statement, the information which has mentioned in the legal document is called the drafting. So how to draft the legal document? What are the essentials of the drafting? We have to understand about the few of the essential elements while drafting. That is the first one, precision. Second one is the clarity, adaptability and lucidity. So while drafting of any document, any legal document, we have to follow the various essential elements. That is the first one, it is the precision. Precision in the sense of whatever the facts, exactly whatever we want, that one only we have to be mentioned. Not to the story related to the particular case. Suppose if it is you want to write about the particular X related property, X property related information you want to give in that document, you have to describe about the particular case only, particular related X related case only, not to the other related, not related to the Y property or to the Z property or any other information. Means you should have to be discussed exact information, accurate information you should mention in the document while any kind of document, whether it may be a deed or it may be any kind of pleadings or in making of any agreement or to the contract. Okay, now we will go to the clarity. So without any ambiguity, you should write clearly, clarity without any ambiguity. Means you want to give any information accurately with the clarity, without any ambiguity, you should mention while drafting of any document. Along with that, adaptability. Adaptability in the sense what? Yes, some of the documents while we will take about the pleadings also, we can alter or amend it. We can do changes. So we should try to write such kind of document where we can adaptability, where we can alter or we can amend. Okay, so along with that, lucidity in the sense what? In simple language we should try to write. We should have to give the information to the other party or to the court with the simple language, not the difficult one. And every person can understand about the particular deed or to the any pleading or any return statement or to the plain copy. Means every person can understand. With the simple words, with simple language, we try to give the information while drafting of every document. So we need to maintain these are the essential elements while writing of any kind of document, that is called the legal drafting. Okay, now we will go to the next one. What is pleading? What are the essential elements of the pleading? Pleading in the sense what? Before the trial part, whatever the process is going on is called the pleading. Before the trial means what? Usually whether it may be the civil related cases or to the criminal related cases, before that whatever the process means, preparing of the plaint, submission of that plaint or to the written statement, all those things which is comes under the pleading. Okay, how to write the pleading? Pleading in the sense we have to write only the facts of the case, but we don't have to be mentioned about the any sections, any acts, any legislation or any evidence. We don't have to be mentioned these all of them. Only we have to be right about to the facts of the case and what the relief we want to ask to the court. Those things only we should have to be right while drafting of every pleading. Okay, along with that, pleadings can be amended or altered with the permission of the court. Yes, we can alter or amend it to the pleadings, and that one will be happen only after the permission of the court. But one thing we have to be remember, if we want to give some value to the particular pleading in the sense, we should describe primarily only. then only we get some value to the particular case. Or else, yes, we can change it, but the court has to satisfy. If the court will give the permission, then only we can alter and amend it to the pleading. Yes, we know that in the pleadings means both the parties signature along with the pleader signature is mandatory. So parties in the sense whether it may be the plaintiff or to the defendant, they also have to be signed on that particular copies along with the pleader signatures also mandatory. So these all are the things are essentials when we try to understand about the pleading. Now we will go to the what is a plaint and the essential elements of the plaint. Plaint means just now I said about the pleading in the sense before the trial part, whatever the process is called is comes under the pleading, and that process, in that process, first thing that plaint initiating any suit in the sense first we have to give that, we have to file the plaint, then only it goes to the written statement. Now plaint in the sense what? Plaint in the sense what? That the aggrieved party, in the sense the plaintiff party urged to the court or claim in the particular court relating to the particular relief, it's relating to the particular relating to the either it may be any case or the property or to the any kind of related cases. So here, how to draft to the plaint? Draft to the plaint in the sense according to the rule 128 of order 7 of the CPC, we have few of the essential elements are there. First thing we have to mention about the title of the court, then the description of the party, then the facts of the case, then along with the cause of action, then the limitation, jurisdiction, prayer and verification. So these all are the steps while drafting of the plaint. We should have to be follow the various steps. First we will go to the title of the court. Title of the court means when drafting of the plaint, first we see that first we mention about the title of the court. In which court we are going to file? In which court means whether in a civil court, senior civil court, junior civil court, according to the jurisdiction in which court we are going, that one you should mention in the title part. Later on we can go to the facts of the briefly or describe about to the facts of the case. That one also we have to follow that essential element just I have discussed, means you clearly, precisely, concisely, and that one is also you should have to be follow the chronological order, means sequentially, means one para is connecting to the another para. Everything you should maintain while drafting of the plaint in the describing about to the facts of the case. Before the title, then the second part it is it's relating to the description part of the parties. First is the title, then the description part of the parties. Description part of the parties in the sense plaintiff name, address, residential area, occupation, everything you have to be describing. Then again it goes to the second one, it is a defendant to whom you are going to file. First, who are going to file, that is the plaintiff party description. Then to whom you are going to file, that is the defendant party's description, means residential area, name, address, everything you have to describe in the description part. Later on, then according to which section you are going to file, that one also you are going to explain about it. Then later on, which goes to the facts of the case. Facts of the case, just now I said you should have to be maintained precisely, concisely, clarity, adaptability, along with that without using of any sections, and it should be chronological order, and it's relating to the previous para, previous information. So like that if you maintain, then it gives some value to your particular document. Along with that, so here next one I said about the cause of action. Cause of action means what? Cause, when the injury happened, when the cause happened. So facts of the briefly you described it, later on the cause of when that cause happened, when the injury happened, that one also you should have tried to mention briefly in that cause of action part. Later on you go with that jurisdiction. Jurisdiction, why you are going to file this court in particular court only, jurisdiction court. So my related cases comes under this particular jurisdiction, so that I am going to file that particular case in particular court only. So that things you are briefly described about to the jurisdiction. Like again, the limitation period. Limitation period means when the cause of action happen, when you are going to file this suit, everything you have to means that is the limitation period. How many years happen? That one also you have to be mentioned later on. Finally, it is the verification. This is what you have to be produce the documents for relating the particular case. That one also you have to mention in the drafting of the particular plaintiff copy. Okay, then here also the plaintiff has to be signed along with the advocate signature. It's a mandatory. Now we will go to the next one. It is the discuss written statement and the essentials of the written statement. Yeah, we know that. The first one, plaint filed by the plaintiff. Okay. After that, the court has to send the summons to the defendant party. Means the court send the summons to the defendant party. With the defendant party after that accepting to that summons, within the 30 days of period of that summons, that the defendant party has to give the written statement. They have to submit the written statement. Suppose if that the defendant has to prolong that period, means 90 days of period has happened or the 120 days of the period happened, then that the defendant has to urge to the court and take the permission of the court. Then if the court satisfied and accept it, then only they can submit it. Otherwise that particular returns will be rejected. So, in generally, after receiving of the summons, within the 30 days of that period, the defendant party has to file the written statement. And how to draft the written statement? Now, what are the essentials to draft the written statement? In the sense what? First, that same like that, here also they have to be follow the particular code and particular description of the parties, along with that whatever you want to be described. Here, that first thing in allegation. Supposing the plaintiff who alleged to the defendant in one para, so you have to give the answer denying to the particular allegation. You are denying to the particular allegation whatever they mention in that paras wise. Paras wise you have to be denying to the each and every allegation. You have to deny to the each and every allegation. Along with that denial of that allegation, you have to add few more points which is useful and beneficiary to the case. Which gives the weightage to your case. You have to add few more points along with the denial of each and every allegation. So here same like that, the written statement, whether it may be whatever it may be, after that they have to give the affidavit. That part we will discuss later. So the signature of the defendant along with the advocate's signature is also mandatory. So those are the things, essentials of the written statement. Now we will go to the difference between suit and petition. Difference between suit and petition. Yes, we have to try to understand about the suit means what, petition means what, application means what, along with that complaint means what. First we try to understand. Suit means it is relating to the civil related cases. Civil related cases, and in the civil courts only we can file. Okay, we can file in the civil related like plaint, written statement, those things we can see in the suit. Here also the aggrieved party asks the relief or the damages from the court. They'll ask the relief or the relaxation or the damages from the court. So now we will go to the what is application means what, or the petition. First petition means what? Petition, it is nothing but if any infringement of constitutional rights happen, then we can approach to the High Court as well as to the Supreme Court. So if constitutional writ means various writs means writ petitions, if habeas corpus, certiorari, mandamus, or various types of writs, we can approach to the High Court as well as to the Supreme Court according to the Article 226 along or in the High Court, when we go to the Supreme Court according to the Article 32. So this petition we can file in this particular courts. So here not only that, petitions we can file in the district courts also when if any injury happened to the family related cases. Means family related cases we can file like divorce related cases, or to the restitution of conjugal right related cases. We can approach to the district court, particular family related cases. Those cases also just comes under those kinds also comes under the petitions. Okay, now that parties, what we can call that parties, what are the names for the particular parties? Here in the suit we use that plaintiff and the defendant, whereas when we go to the petition, when we're going to file a petition, so we use that petitioner and the respondent. Now we next one is that what we try to understand about what is the application. Application in the sense what? Application in the sense in between also they can means the aggrieved party, the individual party can file the application for permanent relief or the temporary relief. But suppose if the party wants to get the temporary relief, means immediate relief, they want injunction order, that is also considered the application. If they want to the permanent relief also, the individual aggrieved party, they can ask to the court, they can ask to the court, then the court will decide whether they have to give that relief or not. On the basis of that particular application, if they will satisfy. So application in the sense, so in between whatever that application, they will give it to the urge to the court relating to the particular cause of action, individual. For suppose if it is relating to my particular property later, I have to be get the relief immediately, or the anything else, then that particular related property will have to be mentioned. Then the court immediately will give on the basis of either injunction permanently or the temporary oath. So this depends upon the discretion of the court. So that is what comes under the so that is related to the application. Now we will go to the complaint. Complaint means we know that. Complaint means first the court will see that whether it may be the what is that cognizable and non-cognizable offences. Cognizable offences means we know very well. Cognizable is a gravity level, severity level is more, like grievous hurt, murder, attempt to murder, or any it's offences related against to the body, offences related to against to the human life. So those all are the offences which is comes under the cognizable offences. So cognizable offences means directly it goes to the FIR, lodge the FIR in the police station, then immediately it goes to that court as per the criteria, whatever that making of the charge sheet, they have to produce that all that information to the court. So this is the connectivity is there. When because of the police only, they will take each and every action where it is relating to the cognizable offences. Whereas what about the non-cognizable offences? It means the gravity level is less. So suppose if it is relating to the family related, harassment related, cruel harassment related, or any other related offences, so in that situation, the complainant only has to approach to the court and file the complaint, and the court will, in the magistrate court, that whatever the action is called and whatever the process is called, here the complainant is there and the respondent is there, to whom you are going to file, that person is called the respondent, to who is the party is called the person who is going to file that complaint is called the complainant. Like that, it is depends upon the particular case. Okay, so this is about the suit, petition, application, and the complaint. Now we will discuss about the original suit and the original petition. Yeah, just now we understood about the what is the suit and what is the petition. Here original suit, in the sense it is related to the particular individual party where we are filing that particular plaint, and that is that the court we use that term, it is the OS in the sense what? Original suit. This is relating to particular individual party, individual property, individual related cases which we can see in the original suit. Whereas now we will go to the original petition. Original petition, it is relating to the we can file in the either in the High Court, or it is relating to the Supreme Court, or to the any district court. It's relating to the family related cases. First we will go to the writ petition. Suppose if it is relating to writ petitions, so we have to be mentioned about the particular party, aggrieved party, along with that state. So this case have to be registered in the particular court. Union versus Union of India versus particular state, state of Punjab, state of Kerala, state of Telangana, state of Andhra Pradesh. So we have to mention about the particular related case or to the country, so that we have to be registered to the particular court. So when we are going to file the any original petition in particular cases, or else if it is relating to the any individual related cases, family related cases, in the sense we have to mention about the particular party X versus Y or anything else. So they have to be described about to the parties, miss petitions, in the sense what all that if any infringement of any constitutional rights happen, or any family related issues happen, then that only we can approach, and that kind of suit is that kind of petitions are called original petition. Original suit and original petition. Okay, now we will go to the difference between the judgment, decree and order. We know very well in every area we use that various terminologies. We said about the judgment, sometimes we said about the decree, sometimes we said about the order. What is the difference between judgment? In this is what on the judgment is the statement given by the judge of the grounds of a decree or order. On the grounds, on base of the grounds of the decree or order, the whatever the statement given, whatever the decision given by the judge is called the judgment. Whereas that the decree or the order is the lower court's decision. Decree or the order is the lower court decision. Here the judgment we cannot appeal for, we cannot go for the appeal, whereas the decree or the order we can go for the appeal. Okay, so here various decrees like declaratory and executory decrees are there, whereas in the orders in the sense interlocutory application, interlocutory or the final order. So these things, interlocutory and the interim order, those also interim order, permanent order, these all are the things we can see in the order. So the decision of the lower court is called the decree and order, and the other part on the basis of the decree and order, whatever the statement, whatever the decision given by the judge is called the judgment. Is it clear? Now we will go to the next part, hierarchy of the court. Yeah, this is the simple one, because every student has to understand about the hierarchy of the court. Sometimes generally the Viva, sometimes they will ask about the, do you have any knowledge about the hierarchy of the courts, where we have to be filed, in which court we have to be filed. So these things also various times the external will ask in the Viva. So first, Supreme Court. Hierarchy of the court, in the sense we know that Supreme Court is the apex court. Supreme Court is the apex court, later on only High Court. Okay, so Supreme Court, apex court, then next one it is the High Court. High Court is also divided into like a state level and the district level. Now state level, in the sense various courts are there. State level related to the civil related cases, criminal related cases, civil related cases in the city civil court, criminal related cases related to session courts. We can approach to the session court, metropolitan session court, cities. Again, we can go to the various city civil courts, like courts of the smaller cases. We can go to other courts. So here state level related courts also be described, whereas when we go to the district level, here in the district level also divided into two parts, that is the civil and the criminal cases. Civil related cases we know the same, like that senior civil court, junior civil courts. Okay, like that. Whereas when we go to the criminal cases, session court, additional metropolitan magistrate court, additional district courts. So these all are the things divided according to the jurisdiction, according to the particular case. We can approach to the various particular courts. So this is the hierarchy of the courts. Now we can go to the, we can try to understand about the what is the IA petition and its essential. So just now I said about the interlocutory application, in the sense why when we can file this application, when we can file we can get this relief, means here after the original suit, means before the original suit, when that whether the plaintiff party or to the defendant party, if they want that relief primarily, whether it may be the temporarily or the permanently, they can go through the IA petition. They can go through the IA petition before the judge, before the original suit, means before that the decision of the original suit, before the decision of the original suit, whatever that relief we want, we can go through that IA petition. In the sense what, it is the intermediate order before the final decision of the suit, according to order 39 rules 6 and 10 of the CPC, deals with the provisions of the IA. IA in the sense what, interlocutory application, is means whether it may be we can get the temporary relief or the permanent relief before that decision of the judgment of the suit, original suit, that comes under the IA. Okay, now we can go to the jurisdiction. What is jurisdiction? Jurisdiction is nothing but it is the particular related, whether it may be pecuniary. Jurisdiction is a two types, that is the territorial jurisdiction and the pecuniary jurisdiction. So here, in every cases, the first we will see about the in which jurisdiction we have to file. Even though the court also accept according to our facts of the case, whether the case can be acceptable or rejected, the court will decide it. Suppose if it is relating to the territorial jurisdiction, suppose is relating to the property related issue, I filed my property is located in the particular Hyderabad area, but I filed in the Delhi, the court will not accept it. The court will reject it because of my property is situated in my particular area. That is the territorial jurisdiction. Wherever the cause of action happened, wherever the injury happened, in that particular area only we have to be filed. Okay, that's why jurisdiction is very important. Whereas when we see about in the drafting of the plaintiff copy also we mention about the jurisdiction, in which jurisdiction we are going to be filed. Pecuniary jurisdiction also same like that. It's relating to the in which court, whether it is a senior or to the junior. It's relating to the money related. Means if suppose if it is the property is relating to the lower related property, less price related property. So in which court we have to be approached, whether junior or to the civil court. The court will decide. Yes, obviously we have to be approached to the junior courts only. If it is more than that, then we can approach to the senior court. So here that jurisdiction and the pecuniary jurisdiction as well as the territorial jurisdiction, according to that only we can file a particular cases. So jurisdiction is also very important. So these all are the questions very important in the DPC Viva. More than not over that, other questions also they will ask in the DPC. So those questions we will discuss in the next class. Thank you.